Ladies and gentlemen, welcome back to the IndieZoNe. My name is Kathy. After a very long, as in a 5-week period of time where absolutely nothing was released to the public from the court case of Idaho versus Kohberger, today, October 10th, 2025, Judge Stephen J. Hippler entered 2 court orders, one amending the other. Both of them were dated October 9th, 5 weeks after the last orders unsealing certain materials with redactions or unsealing them altogether hit the docket. I recommend that you focus your attention on the amended order because this one fixes or corrects the first one. Let's look at this amended order unsealing, redacting, and or maintaining sealed status. Again, this amends, which means it's correcting, it's fixing, it's adding information, it's taking information away from the earlier order. This says, the unsealing of the final track of records identified in the order regarding sealed documents August 4th, 2025. As, and here's the 5 documents in question. These are documents number 5, number 8, number 11, number 17, number 29. And this goes on to say that one or both sides objected to these records insofar as they disclose the names and contact information of potential lay witnesses and potential expert witnesses identified in this case, and they would have been witnesses for the trial that never happened. It was canceled when Mr. Kohberger changed his plea well over 3 months ago. The court then gives a synopsis of what the objections were based on and also giving the legal authority supporting what the parties were saying as grounds to continue to seal this information from public disclosure. Court then says he considered, took under advisement basically in the next paragraph, what the state said, what the defense said, and he is now coming back with this determination. So let's see what the court is saying here. Document number 5, bottom of page 1. This is the July 3rd, 2025 sheriff's return concerning witness KSF. Judge Hippler states here there is no further justification under, and he gives the rule to warrant the continued sealing of this document. However, the court orders that KSF's address be redacted. So therefore, we're going to see a continuing theme here. He's ordering, in some instances, names, but not addresses being redacted. Next page, as it relates to document number 8. This is the June 27th, 2025 sheriff's return concerning witness T as in Thomas, A as in Apple, D, tag. There is no further justification to warrant the continued sealing of this document. However, the court orders that the sealed location of TAD's new address be redacted. Number 11. State's amended notice of compliance and motion to seal state's amended witness list. This is dated June 25th, 2025. The court is saying here there is no further justification to warrant the continued sealing of this document and no valid basis for redactions. This document identifies the names of witnesses, both expert and lay, disclosed by the state in this case. Judge Hippler continues. The majority of the witnesses whose names have been publicly identified have reported no threats or harassment as a result. Of the few publicly identified witnesses who have experienced past threats and harassment, they are largely individuals who had a prominent role in this case. There have been no repeated examples of threats or harassment that have placed a witness's life or safety in danger. The court has found that there's no longer any such threat. In other words, there has not been a compelling showing that a person identified on a witness list will likely face threats or harassment of such a degree to outweigh the public's right to access, particularly given the time that has passed and the corresponding reduction in public furor. The public has now direct access to the most relevant evidence in the case. Ladies and gentlemen, before we go on anymore, I have to respectfully object to Judge Hippler's decision here that the public has access to the most relevant evidence in the case. The public has access to very minimal information. The public has no access to, example, a photograph of this sheath that was supposedly found on the bed in Madison's room that none of the first responders, all 5 of them, mentioned in their reports of November 13th, 2022, and the public has never seen a photograph of it. That's just one example of evidence the public has still not seen, with the 3-year mark of this horrendous tragedy coming up very soon. Going back to Judge Hippler's statement here, the public now has direct access to the most relevant evidence in the case. Thus, the need to chase down all potential leads is alleviated. While some of the listed witnesses may be contacted by the media and potentially harassed or threatened, this remote potential does not justify the continued sealing of the record. Consequently, this record will be unsealed. Number 17. Sheriff's return concerning witness Y. There is no further justification to warrant the continued sealing of these records, and no address identified within the record that requires redaction. Thus, this record will be unsealed. Then, number 29, June 9th, 2025, witness list. Defendant's second amended Phase 2 mitigation witness list. No further justification to warrant the continued sealing of this document, which identifies the names and addresses of individuals. Defendant identified as mitigation witnesses for the same reason identified in 11, super, that means above. Redactions are not warranted to the individual's names, with the exception of CE, whose health condition may render her acutely susceptible to adverse effects from even the potential of threats or harassment if her full name were to be publicly disclosed. Therefore, it is ordered that her full name will be redacted in favor of her initials, as well as the addresses of all individuals listed therein. Mitigation, there's a footnote here. This would be witnesses that the defense would call only in the event of a conviction, because that is what mitigation is. That would be if there was a conviction and this matter would have gone into Phase 2, the penalty phase, to see what the penalty would be, then there would be these witnesses who might help to mitigate on behalf of Mr. Kohberger to possibly render a lesser penalty. And then finally, 41 is the June 4th, 2025 Exhibit S's and Sam 1 to state supplemental response to defendant's request for discovery. Court here saying item number 1 must remain sealed. Why, Judge Hippler? Well, he's saying here as it recites the unrelated criminal history of witnesses who did not testify in this case, which likely would have been unadmissible even if the witnesses had testified. The unsealing of this record would contravene the privacy concerns of these individuals and likely subject them to reputational harm. Thus, the record shall remain sealed, and we see there the signature of Judge Stephen J. Hippler on the 9th day of October 2025. In the next episode, we are going to go over the beginning of these records, as we do. We like to go through them line by line. So please hit the notifications button, subscribe to the channel if you haven't already, so that you will be notified when our follow-up content appears on this IndieZoNe YouTube channel. As always, my comments, my opinions, my speculation are given under the First Amendment to the United States Constitution. If you have any thoughts, comments, opinions that you would like to share with other members of the public, please do so here. Until next time, this is Kathy. Thank you very much for joining us here today.